Judge gives 13 years old death sentence for murdering his own mother. 13 years old. That's how young he was when he sat in that courtroom, staring at the judge with eyes that showed no fear, no remorse, just a cold, empty silence that made everyone uncomfortable. He thought his age would save him. He thought the law would bend because he was just a child. But the evidence didn't care how old he was. The deleted messages didn't lie. The timeline didn't forgive. And the person he had taken from this world? She had been the only one who ever fought for him, his own mother. The judge looked down at the boy, then at the papers before her, and said 5 words that would echo forever. This court has no choice. Stories like this remind us that justice always finds its way. If you believe in accountability, subscribe now and tell us what you think below. This is how it all began. It was a quiet neighborhood, the kind where people knew each other's names, where mothers walked their children to school and neighbors waved from porches. She had lived there for 8 years, raising her son alone after his father left. She worked double shifts at the hospital, came home exhausted, but always made sure he had dinner, always checked his homework, always asked about his day. But somewhere along the way, something changed. The boy who once hugged her goodnight stopped looking her in the eye. The conversations became shorter, the silences grew longer, and on a cold Tuesday morning in October, those silences became permanent. The courtroom was packed that morning, every seat filled, standing room only in the back. Reporters lined the walls with notebooks ready, cameras aimed at the front. This wasn't just another case. This was the kind of trial that made people question everything they thought they knew about childhood, about innocence, about the line between victim and monster. The air felt heavy, like everyone was holding their breath at once. Outside, protesters held signs. Some demanded justice, others begged for mercy. Inside, all eyes were on the small figure sitting at the defense table. He looked so young, so out of place in a room built for adults facing adult consequences. He wore a button-down shirt that was slightly too big for him. His hair was neatly combed. His hands rested on the table, fingers interlocked, like he'd been taught to sit properly in school. But it was his face that unsettled everyone. There was no fear there, no nervousness, no sign that he understood the weight of what was happening. Instead, there was something else, a faint smirk, barely visible, but unmistakable to anyone who looked closely enough. The kind of expression that said he believed this was all temporary, that somehow, some way, he would walk out of here and go back to his normal life. That belief would not survive the next 10 minutes. The judge entered, and the room rose as one. She was a veteran of the bench, known for her fairness and her refusal to let emotion cloud her judgment. She had presided over hundreds of cases, seen things that would break most people, and still managed to find compassion where others saw only guilt. But today, her face was different, harder. The lines around her eyes seemed deeper. She sat down slowly, adjusted her glasses, and looked directly at the boy. He looked back without flinching, that smirk still there, subtle but defiant. A camera shutter clicked somewhere in the gallery. The sound cut through the silence like a knife. The boy didn't even turn his head. The prosecutor stood first, laying out a folder thick with evidence, timelines, digital records, witness statements, forensic reports that painted a picture no one wanted to see. The defense attorney, a woman in her 50s with tired eyes, argued for understanding, for context, for the recognition that children are not fully formed, that their brains are still developing, that punishment should serve rehabilitation, not revenge. She spoke passionately about second chances, about the possibility of redemption, about a system that should protect its youngest members even when they make unthinkable choices. Her voice wavered only once when she glanced at her client and saw that same empty expression staring back at her. But the evidence didn't waver. It didn't bend to emotion or sympathy. The deleted search history had been recovered. Questions about how to avoid detection, research on vulnerable moments, messages that revealed not impulsivity, but planning. Cold, calculated steps taken over days, maybe weeks. And then there was the timeline itself, the moment it happened. The calls that weren't made, the lies that were told, the performance that followed, designed to deflect and deceive. Investigators had interviewed classmates who remembered strange comments, unsettling jokes that no one had taken seriously at the time. Teachers who noticed a shift in behavior, a withdrawal from connection, a growing distance from everyone around him. The pattern was undeniable. The victim's family sat in the front row, their faces frozen in grief that would never fully heal. Her mother, his grandmother, clutched a tissue that had been used so many times it was falling apart. Her brother, his uncle, sat with his jaw clenched, staring straight ahead, refusing to look at the boy who had shattered their family. They had prepared statements, words that tried to capture a lifetime of love and loss in just a few minutes, but no words could truly express what had been taken. A daughter, a sister, a mother who had sacrificed everything, worked herself to exhaustion, and loved unconditionally, even when that love wasn't returned. She had deserved so much more than the ending she received. The judge flipped through the documents before her, reading passages that would later be cited in legal journals and psychology textbooks. She paused on one page longer than the others, her expression unreadable. Then she looked up, removed her glasses, and spoke in a voice that carried to every corner of the room. She acknowledged the defendant's age. She acknowledged the complexity of the case. She acknowledged that what she was about to do would be debated, criticized, and analyzed for years to come. But she also made one thing perfectly clear. The law exists to protect the innocent, and when that protection is violated, consequences must follow. Age does not erase intent. Youth does not justify cruelty. And some actions, no matter who commits them, demand a response that reflects their severity. The boy's smirk began to fade, just slightly, just enough to show that maybe, finally, the reality was beginning to sink in. The judge lifted her gavel, holding it in the air for a moment that seemed to stretch into eternity. The courtroom held its breath. This was the moment everything changed. The moment a child's fate was sealed. The moment justice and mercy collided in a decision that would define not just this case, but the very question of how society should respond when its youngest members commit its darkest crimes. The gavel hung there, suspended between past and future, between childhood and consequence. And then, with a voice that carried the weight of absolute authority, the judge spoke the words that would echo through that courtroom for the rest of their lives. But she did not strike the gavel. Not yet. That sound would come. But first, everyone needed to understand exactly why. Before there was a courtroom, before there were lawyers and evidence and a sentence that would define a generation's understanding of justice, there was a woman. Her name was Sarah Mitchell. She was 34 years old when she passed, though people often said she looked older. The kind of older that comes from years of carrying weight that no one else could see. She worked as a nurse at County General Hospital, pulling 12-hour shifts that often stretched to 14 or 15 when the unit was understaffed. Her co-workers remembered her as reliable, the one who never called in sick, never complained when asked to cover someone else's shift, never left until every patient was settled for the night. She had gentle hands and a quiet voice that somehow made even the most difficult patients calm down. She lived in a modest 2-bedroom house on Maple Street, a quiet residential block where the houses all looked similar and the yards were small but well kept. She had moved there 8 years earlier, shortly after her divorce was finalized. The house needed work when she bought it, but it was all she could afford on a single income while raising a child. She painted the walls herself on weekends, fixed the leaky faucet with a YouTube tutorial and a wrench borrowed from a neighbor, planted flowers in the front yard every spring, even though she barely had time to water them. The house was small, but it was theirs, a place where she thought they could build something stable, something safe, something that felt like home. Her neighbors described her as friendly but private. She waved when she saw people outside, made small talk about the weather or the mail delivery, but she rarely accepted invitations to block parties or neighborhood gatherings. She always had a reason, a shift at the hospital, errands to run, homework to help with. Most people understood. Single mothers didn't have much free time. What they didn't see were the moments when she stood at her kitchen window at night, staring out at the dark street, wondering if she was doing enough, if she was being the mother her son needed, if the exhaustion was normal, or if she was failing in ways she couldn't even recognize yet. She had routines that she followed religiously. Wake up at 5:30 every morning, make coffee, pack lunch for herself and breakfast for her son. Wake him at 6:15. Make sure he ate something, even if it was just toast and juice. Drive him to school by 7:30, then head to the hospital for her shift. She worked from 8 to 8 most days, sometimes longer. On her lunch break, she would call to check in, ask how school was, remind him to do his homework. She came home exhausted, bones aching, feet swollen from standing all day, but she still made dinner, still asked about his day, still tried to maintain some version of normal family life, even though she felt like she was drowning. The exhaustion showed in ways she couldn't hide. dark circles under her eyes that makeup couldn't cover, weight loss that made her uniform hang loose, a cough that lingered for weeks because she never took time off to see a doctor. Her colleagues noticed, asked if she was okay, offered to help. She always smiled and said she was fine, just tired, just busy, just doing what every parent does. But there were moments when the smile didn't quite reach her eyes, when someone would catch her staring at nothing in the break room, lost in thoughts she never shared. When asked directly if everything was all right at home, she would pause just a beat too long before answering. Then she would laugh it off, change the subject, and get back to work. Her relationship with her son had changed over the past year, though she couldn't pinpoint exactly when or why. He used to tell her about his day, about his friends, about things that happened at school, but those conversations had slowly stopped. Now he answered in single words, fine, okay, nothing. He spent more time in his room with the door closed, stopped eating dinner with her, stopped responding when she asked questions. She told herself it was normal. Teenagers pulled away. It was part of growing up. But he wasn't a teenager yet. He was only 13. Still young enough that she thought she should know what was happening in his life. Still young enough that the distance felt wrong, unnatural, like something had broken between them, and she didn't know how to fix it. She tried everything she could think of. Planned special outings that he refused to attend, cooked his favorite meals that he barely touched, asked gentle questions that were met with silence or irritation. She bought him things he said he wanted, hoping that generosity might open a door back to connection, but nothing worked. The wall between them grew thicker. She confided in one friend, a fellow nurse, that she felt like she was losing him, that sometimes when she looked at him, she saw a stranger. Her friend told her to be patient, to give him space, that he would come back to her when he was ready. She wanted to believe that. She needed to believe that. So she kept trying, kept hoping, kept loving him, even when that love wasn't returned. On the last day of her life, she sent him a text message during her lunch break. It was simple, just a few words. Love you. See you tonight. Pizza? 3 sentences that contained everything she still believed about their relationship. That love could survive distance, that routine could create connection, that maybe, just maybe, pizza and a movie might be the thing that finally brought them back together. The message was delivered at 12:17 in the afternoon. It was read at 12:19, but it was never answered. That unanswered text would later become evidence, a timestamp that proved she was still trying, still reaching out, still being a mother right up until the moment she couldn't anymore. The phone was found later, screen cracked, lying 3 feet from where she had fallen, the message still there, waiting for a reply that would never come. Wednesday morning arrived like any other on Maple Street. The sun rose at 6:42, casting long shadows across manicured lawns. Dogs barked for their morning walks. Coffee makers beeped in kitchens up and down the block. Cars backed out of driveways as people headed to work. Everything was normal, routine, exactly as it should be, except for one house. Number 47 sat silent and still, curtains drawn, no lights visible through the windows. The car was in the driveway. The porch light was still on from the night before, but there was no movement. No sign of the woman who usually left for work by 7:15 every morning. Her absence was noticed, but not immediately alarming. People got sick, took days off, overslept occasionally. No one thought to worry. Not yet. By 9 o'clock, the hospital called. Sarah Mitchell had missed her shift without notice, something she had never done in 6 years of employment. No call, no text, no explanation. The charge nurse tried her cell phone 3 times. Each call went straight to voicemail. That was unusual. Sarah always answered, even on her days off. The hospital tried the emergency contact number on file, her brother, who lived 20 minutes away. He said he hadn't heard from her in a few days, but that wasn't strange. They talked weekly, not daily. Still, something about the call made him uneasy. The charge nurse's voice had an edge to it, a concern that went beyond simple annoyance at an absent employee. He said he would drive over to check on her, just to be sure. He arrived at 10:30, parking behind her car in the driveway. The house looked peaceful from the outside. Nothing broken, nothing disturbed. He knocked on the front door and waited. No answer. Knocked again, louder this time. Still nothing. He called her name, pressing his face close to the door, listening for any sound from inside. Silence. He tried the handle. Locked. Walked around to the back door, his unease growing with each step. That door was locked too. He peered through the kitchen window, cupping his hands against the glass to block the glare. The kitchen looked clean, dishes in the drying rack, a coffee mug on the counter, everything normal. Too normal. The kind of normal that felt wrong because it should have been disturbed by now, by morning routines, by life happening. He called the police, told them he needed a wellness check, that his sister wasn't answering her phone, had missed work, and wasn't responding to anyone. The dispatcher asked standard questions. Was she depressed? Any history of mental health issues? Any recent conflicts or threats? He answered no to everything, but his voice shook when he added that she had a 13-year-old son who should have been at school by now. The dispatcher's tone changed, said officers were on their way. Stay outside. Don't enter the home. Help was coming. He stood in the driveway, staring at the house that suddenly felt like a stranger. A place that held secrets he wasn't sure he wanted uncovered. Minutes stretched like hours until the patrol car finally pulled up to the curb. 2 officers approached, asking him to explain the situation again. He repeated everything: the missed shift, the unanswered calls, the locked doors, the silence. One officer walked the perimeter of the house while the other stayed with him, asking more questions. Had there been any domestic issues? Any problems with the son? Any reason to believe someone might want to harm her? He kept saying no, but his certainty was fading. The officer circling the house returned, shook his head. No signs of forced entry, no broken windows, no obvious damage. Everything looked secure from the outside. They made the decision to enter, asked him to wait by the patrol car. He obeyed, watching as they approached the front door with a tool designed to bypass locks without causing damage. The door opened with a soft click. The officers entered, calling out announcements as they moved through the house. Police, making entry for a wellness check. Anyone home? Their voices echoed through rooms that didn't answer back. The brother waited outside, heart pounding, phone clutched in his hand, watching the open doorway like it might reveal answers he wasn't ready to face. 1 minute passed, then 2, then 5. The silence from inside the house became deafening, and then one of the officers appeared in the doorway, face pale, radio already in hand. He didn't say anything to the brother, didn't need to. The look on his face said everything. He spoke into the radio, voice professional but strained, requesting additional units. Detectives, medical examiner, scene preservation protocol. The brother's legs gave out. He sat down hard on the curb, phone slipping from his fingers. More cars arrived within minutes. Unmarked vehicles. Crime scene tape appeared, marking boundaries that transformed a quiet residential street into something else entirely. Neighbors emerged from their houses, drawn by the commotion, whispering to each other behind hands. What happened? Is Sarah okay? Where's her son? Detectives entered the house, spending nearly an hour inside before emerging to speak in hushed tones with the uniformed officers. One detail became clear quickly, shared in whispers that eventually reached the gathering crowd. No forced entry, no signs of a break-in, no indication that anyone from outside had come into that house uninvited, which meant the answer to what happened was somewhere inside those walls. And whoever was responsible had either lived there or been welcomed in by someone who did. A detective approached the brother, who was still sitting on the curb, face buried in his hands. The detective crouched down beside him, voice gentle but direct, asked a question that made the brother's blood run cold. Where is the boy? Where is your nephew? The brother looked up, confusion and horror mixing in his expression. He should be at school. It's Wednesday. He should have been at school since 8 o'clock. The detective pulled out his phone, made a call, spoke quickly to someone on the other end. Then he stood, looked back at the house one more time, and said 5 words that changed everything. We need to find him now. They found him 3 hours later at a convenience store 6 blocks from the house. He was sitting on the curb outside, eating a bag of chips and scrolling through his phone like it was any other afternoon. A patrol officer recognized him from the description that had been circulated. 13 years old, brown hair, wearing a blue hoodie and jeans. The officer approached slowly, keeping his voice calm and non-threatening, asked his name, asked if he was okay, asked if he knew that people were looking for him. The boy looked up with an expression that the officer would later describe as unnervingly blank. He said his name, said he was fine, said he didn't know anyone was looking for him because his phone had died and he'd just been walking around. The officer asked him to come down to the station, said his uncle was worried, said they just needed to talk. The boy shrugged, stood up, and followed without question. At the station, they placed him in an interview room designed to feel less intimidating than the standard interrogation spaces. Softer lighting, a couch instead of metal chairs, posters on the walls with positive messages about making good choices. A detective named Linda Morrison entered, introducing herself with a warm smile. She had years of experience talking to young people, knew how to build rapport, how to make them feel safe enough to open up. She sat down across from him, offered him water and a snack, asked if he was comfortable. He said yes to everything, but his face remained neutral. No anxiety, no confusion about why he was there. Just a strange, flat calm that immediately put her on alert. Something was wrong. She could feel it in her gut. She started with easy questions. How was school? What grade was he in? Did he have friends? Hobbies? He answered in short, simple sentences. School was fine. 8th grade. A few friends. He liked video games. His voice was monotone, almost robotic, like he was reading from a script he'd memorized but didn't really care about. Detective Morrison shifted to more direct questions. When did he last see his mother? What time did he leave for school that morning? Did anything unusual happen last night? His answers came without hesitation, but they were vague. He saw her the night before, left for school around 7:30. Nothing unusual happened. Everything was normal. He kept using that word, normal, like he was trying to convince her, or maybe himself, but the timeline didn't add up. The school had confirmed he never arrived that morning. His name wasn't on the attendance sheet. None of his teachers had seen him. So where had he been between 7:30 and when the officer found him at the convenience store? The detective asked again, more directly this time. The boy paused for the first time, just a fraction of a second, before answering. He said he hadn't felt well, so he decided to skip school and walk around. Just needed some air, needed to think. The detective wrote down his answer, then asked another question. Did he tell his mother he wasn't going to school? The boy said no, said she'd already left for work when he decided, but that couldn't be true. Sarah Mitchell didn't work Wednesdays. She had Wednesdays off every week. The detective didn't reveal this yet, just nodded and kept writing. She brought up the unanswered calls and texts from the hospital, from his uncle, from his mother's friends who had tried to reach her throughout the morning. The boy said he didn't know anything about that, said his phone had died, said he'd been walking around without really paying attention to where he was going, lost track of time. The detective asked if he had a charger. He said yes, but he forgot to bring it with him. She asked why he didn't go home to charge it when he realized it was dead. He shrugged, said he didn't think it was important. That answer hung in the air between them. His mother missing, his phone dead, hours of being unreachable, and he didn't think it was important enough to go home. The detective's expression didn't change, but inside, alarm bells were screaming. Another detective entered the room, whispered something to Morrison. She nodded, stood up, told the boy she'd be right back. In the hallway, her colleague showed her something on a tablet. Surveillance footage from a neighbor's security camera. The timestamp showed 7:42 that morning. The video showed the boy leaving the house, walking down the driveway, turning left toward the main road. But there was something else. He stopped at the end of the driveway, looked back at the house for a long moment. Then he reached into his pocket, pulled out his phone, looked at the screen, and put it back. The phone was working. It wasn't dead. He had lied. And if he had lied about something that small, that verifiable, what else was he lying about? Detective Morrison returned to the room, sitting down with a different energy now, less warm, more focused. She asked him again about the phone. Are you sure it was dead this morning? The boy nodded, maintaining the same flat expression, completely sure. She showed him the footage on her tablet. His face didn't change, didn't show surprise or guilt or anything that might indicate he'd been caught in a lie. He just watched the video, then looked back at her, said the phone must have died after that, must have run out of battery while he was walking. The detective asked when exactly, what time. He said he didn't remember, wasn't really paying attention. She asked what he was doing on the phone at 7:42. He said he was just checking the time, nothing else, just the time. The interview continued for another hour. Every answer felt rehearsed. Every explanation felt hollow. He showed no concern for his mother's whereabouts, no worry about why so many people were looking for him, no emotional response to anything that was happening. At one point, Detective Morrison asked him directly if he loved his mother. The boy looked at her with those empty eyes and said yes in the same tone he'd used to say the sky was blue, a statement of fact with no feeling behind it. She asked if he was worried about her. He said he guessed so, but she was probably just busy at work. The detective reminded him that his mother didn't work on Wednesdays. The boy blinked once, slowly, then said maybe she picked up an extra shift. Maybe someone called in sick. It happened sometimes. Then he said something that made everyone in the observation room freeze. The detective had asked him what he thought might have happened to make his mother miss work and not answer her phone. The boy tilted his head slightly, almost like he was considering the question for the first time. And then he said, in that same flat voice, without a trace of emotion, maybe she finally got tired of everything and just left. She always said she was exhausted. Maybe she just needed a break from me. The words hung in the air like poison. A 13-year-old suggesting his mother abandoned him without a hint of sadness or confusion. Just cold, detached possibility. Detective Morrison's pen stopped moving. She looked at the boy for a long moment. Then she stood up and left the room. They needed to recover his phone. They needed to see what he'd deleted. Because this wasn't grief. This wasn't confusion. This was something else entirely. The phone was still in his pocket when they asked for it. He handed it over without resistance. That same blank expression on his face. No hesitation. No concern about what they might find. Either he believed he'd covered his tracks well enough, or he simply didn't care anymore. The device was taken to the department's digital forensics unit, where a specialist named Marcus Chen had seen just about everything a phone could hide. Deleted texts, hidden apps, encrypted messages, browser histories people thought were gone forever. But nothing was ever really gone. Not completely. Digital information left shadows, traces, footprints that skilled investigators could follow back to the truth. Marcus plugged the phone into his system and began the extraction process. Within minutes, his screen filled with data, and what he found made him immediately call Detective Morrison. The browsing history went back months. At first, it looked like typical content for a 13-year-old. Gaming forums, music videos, social media. But then the searches changed, started getting darker. 3 months ago, the first concerning query appeared. How to make someone stop bothering you forever. It could have been innocent. Kids dealt with bullies, had conflicts with peers, but the searches that followed removed any doubt about innocence. What happens if someone stops breathing? How long before someone notices a missing person? Do kids go to jail for accidents? Each search more specific, more focused, more revealing of an intent that no child should have been developing in the quiet hours of night while his mother slept down the hall. The timeline showed escalation. 2 months ago, the searches became more technical. How to delete text messages permanently. Can police recover deleted photos? What evidence do investigators look for? He was researching not just harm, but concealment. Planning not just an action, but an escape from consequence. Marcus scrolled through page after page, his jaw tightening with each new discovery. There were visits to forums where people discussed true crime cases, reading about mistakes killers had made, techniques investigators used, legal loopholes that had allowed some defendants to avoid maximum sentences. He was studying, learning, preparing himself for something he knew was wrong, but was determined to do anyway. The deleted messages were even worse. The phone's operating system kept backups that most users didn't know existed. Marcus recovered conversations from the past 6 weeks, messages to classmates that revealed a disturbing mindset. One exchange stood out. A friend had complained about his own mother grounding him for bad grades. The boy had responded with a message that made Marcus's stomach turn. At least you can just wait it out. Some problems you have to solve permanently. The friend had sent back a laughing emoji, clearly thinking it was a joke. But 3 more messages in that thread suggested it wasn't. I'm serious, though. Sometimes people just don't get that you're done dealing with them. Sometimes you have to make them understand. The friend had stopped responding after that. There were also messages he'd sent to himself, a habit some people developed using their own number as a private notepad. These messages read like a disturbing journal. She won't listen, never listens, acts like she knows everything, tired of the questions, tired of the checking in, tired of her acting like she cares when she just wants to control me. Everyone would be better off. She'd stop being stressed. I'd stop being suffocated. It makes sense. Each message more detached, more rationalized, more convinced that what he was planning was somehow logical, even justified. The final message in this chain was sent at 11:17, the night before his mother died. Just 2 words. Tomorrow morning, Marcus compiled everything into a report and sent it to Detective Morrison within hours. She read it twice, each time hoping she'd misunderstood something, that there was another interpretation that didn't lead to the obvious conclusion. But there wasn't. This wasn't an impulsive act. This wasn't a moment of anger that got out of control. This was premeditated, researched, planned over weeks with the kind of cold calculation that most adults would struggle to execute. She forwarded the report to the prosecutor's office with a note that said simply, "We need to talk about charges." The prosecutor, a veteran named Robert Chen, who had handled hundreds of juvenile cases, called her back within 30 minutes. His voice was strained when he spoke. They were in uncharted territory. The legal question was complicated. The boy was 13, still legally a child, still protected by laws designed to recognize that young people's brains weren't fully developed, that they deserved opportunities for rehabilitation rather than punishment. But the evidence suggested someone who understood exactly what he was planning to do, who researched consequences, who took steps to avoid detection, who showed clear awareness that his actions were wrong, illegal, and harmful. The prosecutor reviewed precedent cases, looked at state law regarding juvenile offenders, consulted with colleagues who specialized in cases involving young defendants. The conversation kept coming back to one central question. At what point does age stop being a shield against accountability? By evening, a decision was made. The charges would be filed in adult court. First-degree intentional harm. The language was carefully chosen to avoid the most severe terminology while still reflecting the gravity of what the evidence showed. It was a compromise between recognizing his age and recognizing his actions. The prosecutor knew it would be controversial. New defense attorneys would argue it was too harsh. New child advocates would protest. But he also knew that the victim deserved justice, and justice couldn't turn a blind eye to evidence this clear. He prepared the charging documents, reviewing each word multiple times before signing his name at the bottom. Then he looked at the file one more time, at the timeline of searches and deleted messages and calculated deception, and said aloud to his empty office, "This was planned, every single part of it." The court ordered a comprehensive psychological evaluation, standard procedure in cases involving juvenile defendants, especially when adult charges were being considered. 2 experts were assigned to assess him independently. Dr. Sarah Winters, a child psychologist with 20 years of experience working with at-risk youth, and Dr. James Hartford, a forensic psychiatrist who specialized in evaluating defendants for trial competency and criminal responsibility. Both had seen hundreds of young people who'd made terrible choices. Both had worked with children who'd committed serious offenses. But both would later say that this evaluation was different, unsettling in ways that were hard to articulate but impossible to ignore. The boy sat across from them in separate sessions, answering questions with that same flat effect that had disturbed the detectives. No emotion, no connection, just words delivered like he was reading from a script written by someone else. Dr. Winters started with baseline assessments. Intelligence testing showed he was above average, functioning in the superior range for his age. No cognitive impairments, no learning disabilities, no developmental delays that might explain difficulty understanding consequences or social norms. She moved on to emotional assessments, asking him to identify feelings in photographs of faces. He got them all correct, could recognize sadness, anger, fear, joy. But when she asked him to describe times he'd felt those emotions himself, his answers were shallow. Textbook responses that lacked genuine personal connection. He said he felt sad when his pet fish died in 3rd grade. Said he felt angry when kids teased him at school. But the way he described these experiences felt rehearsed, like he knew what answers were expected, but didn't actually feel what he was describing. The questioning turned to his relationship with his mother. Dr. Winters asked him to describe her. He listed facts, her job, her schedule, her habits. When pressed for emotional descriptors, he struggled, said she was nice and worked a lot. When asked what he loved about her, he paused for a long time before saying she made good spaghetti. The answer was so detached, so devoid of real affection, that Dr. Winters had to work hard to keep her professional composure. She asked if he missed her. He said he didn't know yet, because not much time had passed. She asked if he felt sad about what happened. He said he felt bad that people were upset, not sad about the loss itself, just uncomfortable with the disruption it had caused. The distinction was chilling. Dr. Hartford approached the evaluation from a forensic angle, focusing on the boy's understanding of right and wrong. He presented hypothetical scenarios. If someone takes something that doesn't belong to them, is that right or wrong? Wrong. If someone hurts another person on purpose, is that right or wrong? Wrong. If someone plans to hurt someone and then does it, is that worse than doing it without planning? Yes, because planning means they had time to stop themselves. Every answer was correct. Every response demonstrated clear comprehension of moral and legal boundaries. He understood consequences, understood that actions had victims, understood that society punished people who violated these rules. His knowledge was perfect. His emotional connection to that knowledge was non-existent. The school was contacted. Teachers and classmates were interviewed. A picture emerged that aligned with what the psychologists were finding. He was a quiet student, neither popular nor particularly isolated. He participated in class when called on, but rarely volunteered. Completed assignments adequately, but without passion or engagement. Teachers described him as unremarkable, the kind of student who blended into the background and never caused problems. But some classmates had different memories. One girl recalled him making strange comments during a discussion about death in history class. The teacher had been explaining casualties in a war, and he'd raised his hand and said, "It's interesting how easy it would be to make someone disappear if you were smart about it." The class had gone silent. The teacher had redirected the conversation quickly, uncomfortable with where it was going. Another classmate remembered him talking about getting away with things. They'd been discussing a news story about a criminal who'd been caught years after committing a crime. The boy had said with complete confidence that the person had made stupid mistakes, that if you were careful and patient, you could do almost anything without getting caught. You just had to think ahead, plan properly, not act on impulse. His friend had laughed nervously and changed the subject, but the comment stuck with him, especially now, knowing what had happened. Looking back, the signs had been there. Small moments that seemed odd but not alarming enough to report. Comments that were unsettling but could be dismissed as a kid trying to sound edgy or interesting. Red flags that no one recognized until it was too late. Dr. Winters and Dr. Hartford submitted separate reports that reached the same conclusion. The defendant demonstrated significant emotional detachment and lack of empathy. His ability to intellectually understand moral concepts was intact, but his emotional engagement with those concepts was severely impaired. He showed no genuine remorse for the harm caused, no authentic grief over the loss of his mother, no real concern about the consequences he was facing. The pattern suggested a level of emotional disconnection rarely seen in someone so young. Both experts noted that this wasn't a case of impulsivity or poor judgment. It wasn't a child who acted without thinking. It was someone who thought very carefully, understood the weight of what he was planning, and chose to proceed anyway. The most damning part of both evaluations came in the final assessment. Dr. Hartford's report included one line that would be quoted repeatedly in the trial. The defendant's cognitive understanding of right and wrong is not impaired. His capacity to conform his behavior to the law is intact. His ability to appreciate the consequences of his actions is well developed. He understood that what he was planning was morally wrong, legally prohibited, and would cause irreparable harm, and he made a deliberate choice to do it anyway. Dr. Winters' conclusion was simpler but equally clear. This is not a child who didn't know better. This is a child who knew exactly what he was doing and decided that what he wanted mattered more than another person's life. The reports were filed with the court. The psychological picture was complete, and it was deeply, profoundly disturbing. News of the charges spread through the community like wildfire. Within hours, every local news station carried the story. A 13-year-old boy charged as an adult in the death of his own mother. The details were limited at first, protected by juvenile privacy laws that were now being challenged by the severity of the charges. But enough information leaked through court filings and anonymous sources that people began forming opinions long before any trial date was set. Social media exploded with reactions. Comment sections filled with heated debates. Hashtags trended. The case became national news within 48 hours. Television pundits discussed it on morning shows. Legal experts weighed in on cable news. Opinion pieces appeared in major newspapers. Everyone had something to say about what should happen to a child who had allegedly done something so unthinkable. The community organized a vigil for Sarah Mitchell 3 days after her death. Hundreds of people gathered in the park near her home, holding candles that flickered in the evening breeze. Co-workers from the hospital spoke about her dedication and kindness. Neighbors shared memories of her quiet generosity, the times she'd helped carry groceries or checked on elderly residents during storms. Her brother stood at the front, struggling to find words adequate for the moment. He talked about his sister's strength, her determination to build a good life for her son despite working exhaustion and financial struggles. He talked about her hope that things would get better, that the hard years were temporary, that eventually everything she was sacrificing would pay off. His voice broke when he said she never got to see that future, never got to rest, never got to be anything other than tired. But even as people mourned, the conversation kept returning to the boy. What should happen to him? How should justice be served? The community fractured into distinct camps almost immediately. Some argued that he was still a child, that brain science showed adolescents couldn't fully understand consequences, that the system existed to rehabilitate young offenders, not destroy their lives before they'd barely begun. They pointed to his age, to the possibility of trauma or mental illness that hadn't been properly addressed, to the fundamental belief that children deserved second chances no matter what they'd done. These voices were loud on social media, organizing petitions, asking for the charges to be reduced, for the case to remain in juvenile court, for mercy to guide the process. Others argued just as passionately for accountability. They pointed to the evidence of planning, to the searches and deleted messages that showed clear intent and understanding. They talked about the victim, about Sarah Mitchell's right to justice, about the message society would send if someone could plan and execute such harm and escape serious consequences simply because of their age. These voices filled different comment sections, different petitions, different protest groups. They stood outside the courthouse holding signs that demanded justice, that insisted age couldn't be an excuse for calculated violence, that some actions were so severe they required severe responses regardless of who committed them. The two sides rarely engaged with each other constructively. Mostly they shouted past each other into echo chambers that reinforced existing beliefs. The media coverage intensified the division. Every news cycle brought new angles, new experts, new opinions. Child psychologists appeared on television explaining adolescent brain development, how the prefrontal cortex wasn't fully formed until the mid-20s, how this impacted decision-making and impulse control. Prosecutors and legal analysts countered with discussions of precedent, of cases where juveniles had been tried as adults, of the need for justice to reflect the severity of harm caused. Victims' rights advocates spoke about Sarah Mitchell, about the finality of death, about how rehabilitation for the offender couldn't bring back what was taken. Defense attorneys talked about the failures of adult prison systems, about how incarcerating children with adult offenders created worse outcomes, about the purpose of juvenile justice being fundamentally different from adult punishment. Online debates became vicious. People who argued for leniency were accused of not caring about the victim, of prioritizing the perpetrator over the person who'd been harmed. People who argued for adult prosecution were accused of cruelty, of wanting revenge rather than justice, of failing to understand child development and trauma. Threats were made on both sides. Accounts were blocked. Friendships ended over disagreements about what should happen to a 13-year-old defendant most people had never met. The case stopped being about the specific facts and became a referendum on broader beliefs about crime, punishment, childhood, accountability, and what society owed to both victims and offenders. Local businesses took sides. Some displayed signs supporting juvenile justice reform, calling for the case to be handled with age-appropriate interventions. Others displayed photos of Sarah Mitchell with messages about remembering the victim, about refusing to let sympathy for youth overshadow the reality of what had been lost. The town that had once been quiet and cohesive was now split down in visible lines that ran through every street, every workplace, every conversation. People who'd lived as neighbors for years suddenly found themselves on opposite sides of an unbridgeable divide. The case wasn't just about one boy anymore. It had become a mirror reflecting every community member's deepest beliefs about justice, mercy, childhood, and consequence. The prosecutor's office released an official statement 6 days after the arrest. The charges were formally announced at a press conference carried live on 3 local stations and streamed online. Robert Chen stood at a podium surrounded by microphones, reading from prepared remarks that had been carefully crafted to balance legal precision with public communication. First-degree intentional harm, prosecuted in adult court, No plea offers at this time. The investigation was ongoing, but the evidence was substantial. A trial date would be set within 60 days. Questions were shouted from reporters. Would they seek the maximum sentence? What message did this send to other juveniles? Did they believe a 13-year-old could truly understand what he'd done? Chen answered some, deflected others, and ended the conference by saying one thing that everyone could hear clearly. This case will be decided by evidence, not emotion, by facts, not feelings. And the facts are undeniable. The trial began on a cold Monday morning in late November. The courthouse, an imposing brick building that had stood downtown for 70 years, had never seen this level of public interest. News vans lined the street. Satellite dishes pointed skyward. Reporters practiced stand-ups on the courthouse steps while camera operators adjusted their equipment. A line of people hoping for seats in the public gallery had formed before dawn, wrapping around the block, some holding thermoses of coffee and blankets against the chill. Security was tripled. Metal detectors were installed at every entrance. Officers checked bags and wanted each person entering the building. The atmosphere felt less like a trial and more like a historic event that people wanted to witness firsthand, to say they were there when justice confronted its most difficult questions. Inside, the courtroom had been prepared with meticulous care. Every wooden bench polished, every surface cleaned, the flags hung straight. The witness stand positioned precisely, the jury box empty but ready, the judge's bench elevated, commanding, impossible to ignore. Seats were assigned to family members, to media representatives, to legal observers and law students who'd requested permission to attend. The general public filled the remaining space on a first-come basis, creating a lottery of sorts where some people waited hours for seats, while others were turned away at capacity. Those who made it inside sat quietly, speaking in whispers, aware that something significant was about to unfold. The weight of the moment pressed down on everyone who entered that room. The prosecution team arrived first, wheeling cases filled with binders and evidence files. Robert Chen led the team, flanked by two assistant prosecutors who'd been working the case alongside him. They set up at their table with practiced efficiency, organizing materials in a specific order, technology ready for presentations they'd rehearsed dozens of times. Chen looked tired. The case had consumed months of his life, countless late nights reviewing evidence, preparing witnesses, anticipating defense strategies. But his focus was absolute. He nodded politely to colleagues and court staff but said little, conserving energy for the performance ahead. This wasn't just another case for him. It was a defining moment in a career built on pursuing justice for those who could no longer speak for themselves. The defense team entered minutes later. Lead attorney Margaret Foster was a respected juvenile defense specialist, known for her passionate advocacy and her refusal to give up on young clients regardless of public opinion. She'd taken this case knowing it would destroy her reputation in certain circles, knowing people would accuse her of defending the indefensible. But she believed deeply in the principle that everyone deserved competent representation, that the system only worked when even the most unpopular defendants had someone fighting for their rights. She carried herself with quiet dignity, aware of the hostile stares from the gallery, the whispers that followed her down the aisle. Her team set up across from the prosecution, their materials focused less on proving innocence and more on arguing context, on asking the jury to see a child rather than a monster. Then he entered, escorted by two bailiffs wearing clothes his attorney had selected to make him look as young as possible, a button-down shirt in soft blue, khaki pants. No handcuffs visible, though everyone knew they'd been removed just before he entered public view. He walked with steady steps, no hesitation, no visible fear, found his seat at the defense table, and sat down without looking around, without acknowledging the hundreds of eyes fixed on him. His expression was the same one detectives and psychologists had described: blank, neutral, empty of any emotion that might reveal what he was thinking or feeling. The gallery reacted in whispers. Some people had expected to see a scared child. Instead, they saw someone who looked disturbingly comfortable, like this was an inconvenience rather than a trial that would determine the rest of his life. The bailiff called for everyone to rise. The room stood as one. Judge Patricia Moreland entered from her chambers, robes flowing, face composed in professional neutrality. She was in her late 50s, gray hair pulled back, wire wire-rimmed glasses perched on her nose. She'd been assigned this case specifically because of her reputation for fairness and her experience handling complex juvenile matters. She'd presided over difficult trials before, cases that tested the limits of law and conscience. But colleagues said this one was different. The evidence was compelling. The defendant was shockingly young. The legal questions touched fundamental beliefs about childhood and accountability. She took her seat, arranged her materials, and looked out over the courtroom with eyes that had seen too much suffering but refused to become cynical. She understood the weight of what she was about to oversee. Opening statements would come after jury selection, but first Judge Moreland addressed the courtroom directly. She outlined rules of conduct: no outbursts, no emotional displays, no recording devices. Respect for the process was mandatory, and violations would result in immediate removal. She spoke about the gravity of the charges, the seriousness of the proceedings, the importance of allowing justice to unfold without interference from public passion. Her voice was firm but not unkind, commanding attention without raising volume. She made eye contact with different sections of the gallery, making sure everyone understood that this courtroom belonged to the law, not to anger or grief or opinion. Only evidence would matter here. Only facts would guide decisions. Everything else was noise that had no place in this sacred space. Jury selection began immediately after her remarks. Potential jurors filed in, faces revealing various degrees of nervousness and curiosity. The voir dire process would take days, maybe weeks. Each potential juror would be questioned about their ability to be fair, their exposure to media coverage, their personal beliefs about juvenile justice and adult prosecution of minors. Many would be dismissed for cause, having already formed opinions too strong to set aside. Others would be struck by attorneys using peremptory challenges, removed for reasons they'd never fully understand. The process was tedious but essential. 12 people would ultimately be chosen to decide this case, 12 strangers who would carry the burden of judgment. And as the questioning began, the defendant sat motionless at his table, occasionally whispering to his attorney, but mostly just watching with those empty eyes that revealed nothing. The trial had begun. Jury selection took 9 days. 93 potential jurors were questioned. 67 were dismissed for various reasons. 12 were finally seated, along with 4 alternates. They represented a cross-section of the community: teachers, retail workers, a retired engineer, a stay-at-home parent, a small business owner. Ages ranged from 24 to 68. Each had sworn under oath that despite everything they'd heard, despite opinions they might have formed from news coverage, they could set aside preconceptions and decide this case based solely on evidence presented in court. Whether that was truly possible remained to be seen. But Judge Moreland accepted their assurances, and the trial moved forward into its most crucial phase: the presentation of evidence, the moment when theory became proof, when accusations became facts, when the story stopped being something people argued about online and became something that had to be confronted directly. Robert Chen stood for his opening statement on a Tuesday morning. The courtroom was packed, every seat filled, tension thick enough to cut. He walked to the center of the floor, positioned himself where every juror could see him clearly, and began speaking in a voice that was calm but carried absolute conviction. He told them they would see evidence that removed all doubt, digital records that couldn't be explained away, timeline inconsistencies that revealed deception, psychological evaluations that showed clear understanding of right and wrong. He promised them that by the end of this trial, they would know beyond any reasonable doubt that this was not an accident, not a moment of childish impulse, but a planned act carried out with full awareness of its consequences. He spoke for 27 minutes, outlining the case piece by piece, building a framework that would support everything they were about to see. Margaret Foster's opening was different. She stood before the jury and asked them to remember one fundamental truth. Her client was 13 years old, a child by any legal, psychological, or moral standard. She acknowledged that something terrible had happened, that a life had been lost, that grief was real and justified, but she urged them to consider context, to think about childhood trauma they didn't fully understand yet, to remember that adolescent brains were wired differently than adult brains, that capacity for judgment and impulse control were still developing. She talked about the purpose of juvenile justice, about rehabilitation versus punishment, about whether destroying another life served any purpose beyond revenge. Her words were passionate and sincere, but they faced an uphill battle against the evidence that was about to be presented, evidence that would test every generous assumption about childhood innocence. The prosecution's first witness was the digital forensics expert, Marcus Chen. He took the stand with a tablet and a presentation already loaded, ready to walk the jury through months of recovered data. He explained in simple terms how phones stored information, how deleted content could be retrieved, how timestamps created irrefutable timelines. Then he showed them the search history. Each query appeared on a screen visible to the entire courtroom. How to make someone stop bothering you forever? The jury shifted uncomfortably. What happens if someone stops breathing? Someone in the gallery gasped quietly. How long before someone notices a missing person? The queries kept coming, each one more damning than the last, each one revealing a mind moving steadily toward a predetermined conclusion. Marcus explained the progression, the pattern of research that showed planning over impulse. Then came the deleted messages. Marcus read them aloud, his professional tone making the words somehow more chilling, the casual discussion of permanent solutions, the rationalizations typed out in the middle of the night, the final message sent at 11:17 the evening before. Tomorrow morning, the courtroom sat in absolute silence as those two words hung in the air. Foster objected twice during the testimony, arguing that search history could reflect curiosity rather than intent, that teenage messages were often exaggerated and shouldn't be taken literally. Both objections were overruled. Judge Moreland allowed the evidence, noting that the jury was capable of interpreting the material in proper context. The damage was done. Faces in the jury box had shifted from neutral observation to visible concern. This wasn't looking like a child who'd made a mistake. This looked like someone who'd researched and planned. The forensic pathologist testified next, keeping descriptions clinical and avoiding graphic details per the judge's instructions. She explained her findings in medical terms that painted a clear picture without traumatizing the courtroom. Time of death established between 7 and 8 in the morning. The location and circumstances consistent with the prosecution's timeline. No evidence of an intruder. No signs of forced entry or struggle that would suggest someone from outside the home was responsible. Everything pointed to someone who lived there, someone who had access, someone who knew the victim's routines and vulnerabilities. Foster's cross-examination focused on uncertainties, on the limits of forensic science, on alternative possibilities. But the core facts remained unchanged. The evidence pointed in one direction, and that direction led directly to the defendant sitting quietly at the defense table. Detective Morrison took the stand on the fourth day of testimony. She walked the jury through the investigation step by step. The initial interview, where stories didn't match reality, the surveillance footage that proved the phone wasn't dead, the flat effect and absence of appropriate emotional response, the chilling comment about his mother getting tired and leaving. She described her years of experience interviewing young people, her training in recognizing deception, her certainty that something was deeply wrong with the defendant's presentation from the very first conversation. Foster challenged her interpretations, argued that detective work wasn't psychology, that assuming guilt based on demeanor was prejudicial and unreliable. But Morrison held firm. She'd interviewed hundreds of children in crisis. She knew what genuine confusion looked like, what real grief felt like. And this wasn't it. Dr. Hartford's testimony brought the psychological evidence into sharp focus. He explained his evaluation process, his findings, his conclusions. The defendant understood right from wrong, understood consequences, understood that what he was planning was both morally wrong and legally prohibited. He chose to proceed anyway. The cognitive capacity was intact. The emotional connection was absent. Foster tried to reframe this as evidence of mental illness, of a child who needed treatment rather than punishment. But Hartford was clear. Lack of empathy didn't equal lack of understanding. The defendant knew what he was doing, knew it was wrong, did it anyway. That met the legal standard for criminal responsibility regardless of age. The jury listened intently. intently, some taking notes, others just staring at the boy who sat motionless throughout testimony about his own psychological profile. By the end of the second week, the prosecution had presented 23 witnesses and 67 pieces of evidence. The timeline was established. The digital footprint was undeniable. The psychological profile was clear. The investigation had been thorough and professional. Every piece fit together into a narrative that was difficult to dispute. The defense had fought hard, objected frequently, cross-examined aggressively, but they were defending against facts, and facts were stubborn. As the prosecution rested its case, Robert Chen looked at the jury and said simply, "The evidence has spoken. Now you must decide what it means." The weight of that responsibility showed on every face in the jury box. One woman in the back row wiped away tears, overwhelmed by the sadness of it all. A child? A mother? A loss that could never be undone. And a question with no good answer. What does justice look like when everyone involved has already lost everything? The defense case began on a Monday morning, 3 weeks into the trial. Margaret Foster had a difficult task ahead of her. She couldn't dispute the evidence. The digital footprint was real. The timeline was accurate. The psychological evaluations were professionally conducted. Instead, she had to reframe everything. Ask the jury to see her client not as the calculating figure the prosecution had painted, but as a troubled child whose actions stemmed from circumstances beyond his control. She called witnesses who testified about the challenges of single-parent households, about the isolation children felt when parents worked long hours, about developmental stages where empathy was still forming. Expert witnesses discussed adolescent brain development, explaining with charts and studies how the prefrontal cortex wasn't fully mature until the mid-20s, how this affected decision-making, impulse control, understanding of long-term consequences. The testimony was informative and well presented, but it felt abstract compared to the concrete evidence the prosecution had offered. Then Foster made a decision that surprised everyone in the courtroom. She announced that the defendant himself would testify. Gasps rippled through the gallery. Prosecutors exchanged glances, a mix of surprise and anticipation. Putting a defendant on the stand was always risky. Putting a 13-year-old charged with such a serious offense was almost unprecedented, but Foster believed it was necessary. The jury needed to see him as human, as a child capable of emotion and remorse, as someone worthy of rehabilitation rather than lifetime punishment. She'd spent hours preparing him, coaching him on how to speak, how to show appropriate emotion, how to answer questions in ways that revealed vulnerability rather than calculation. Whether those hours of preparation would be enough was about to be tested in the most public way possible. He took the stand on a Wednesday afternoon. The courtroom fell absolutely silent as he walked from the defense table to the witness box. He looked small there, dwarfed by the wooden structure designed for adults. The bailiff administered the oath. He raised his right hand and promised to tell the truth. His voice was steady, neither nervous nor confident, just flat, neutral, the same tone that had disturbed every professional who'd interviewed him. Foster began with gentle questions, asked him to state his name and age for the record, asked about his school, his interests, his daily life before everything changed. He answered in complete sentences, polite and articulate, but there was something missing. The warmth that should come from a child talking about his life, the natural energy of adolescence. He spoke like someone reading a script, hitting all the right notes technically, but missing the music underneath. Foster moved to more difficult territory, asked him about his relationship with his mother. He described her work schedule, her routines, her habits. When asked what he loved about her, he paused for several seconds, then said she worked hard and tried to take care of him. The answer was so clinical, so devoid of genuine affection, that several jurors visibly reacted. Foster tried to redirect, asked about specific memories, holidays they'd celebrated, moments they'd shared. He provided facts. Christmas 2 years ago, they'd gotten a tree. Last summer, they'd gone to a park once. His birthday, she'd made cake. Every memory stripped down to bare information with no emotional color. Foster's frustration was beginning to show. She'd prepared him to be vulnerable, to show the jury his humanity. Instead, he was reinforcing every concern the prosecution had raised about his emotional detachment. Then she asked the question she'd been building toward. Did he regret what happened? The courtroom leaned forward collectively. This was the moment that mattered. The chance for him to show remorse, to demonstrate that beneath the flat effect was a child capable of understanding the weight of loss. He looked directly at Foster, then turned to face the jury. His expression didn't change, and he said in that same neutral tone, "I regret that things turned out this way. Not I regret what I did. Not I'm sorry for the pain I caused. Just regret that things turned out this way," like he was discussing a disappointing test score rather than a death. Foster quickly moved to clarify, asked him to explain what he meant. He said he wished circumstances had been different, that if certain things had changed, maybe this wouldn't have happened. Still no ownership, still no direct acknowledgement of his own actions. Robert Chen's cross-examination was surgical. He started with the search history, asking the defendant to explain each query. Why did you search for how to make someone stop bothering you forever? The boy said he was just curious about different topics. Why did you search for how long before someone notices a missing person? He said he'd been reading about missing person cases in the news. Every answer was evasive, deflecting responsibility, treating the evidence as if it belonged to someone else. Chen pressed harder, asked about the deleted messages, about the comment to his friend that some problems needed to be solved permanently. The boy claimed it was just talking, that teenagers exaggerated all the time, that nothing he said online should be taken seriously. Chen showed him his own words on the screen, asked him to read the message sent at 11:17 the night before his mother died. Tomorrow morning, asked him what that meant. The boy said he didn't remember what he was referring to. Maybe a test at school, maybe plans with friends. Then Chen asked the question that would define the rest of the trial. He looked at the defendant and said slowly, carefully, "Do you feel sorry that your mother is gone?" The courtroom held its breath. This was the moment. The chance for genuine remorse to appear, for the emotional wall to crack, for some sign that a 13-year-old child understood the magnitude of loss. The boy looked at Chen, then at the jury, then back at Chen. Several seconds passed, and then he answered with 5 words that made the courtroom go absolutely silent. "I feel sorry people are upset, not sorry she was gone. Sorry that her death upset other people." The distinction was razor thin but devastating. He'd just revealed exactly what the psychological evaluations had documented. He could understand intellectually that death caused grief, but he felt no personal connection to that grief, no genuine sorrow for the loss itself, only discomfort with how the loss affected him. The silence that followed was deafening. No one moved. No one spoke. Even Judge Moreland seemed momentarily frozen, processing what had just been said. Chen stood there for a moment, letting the answer sink into every mind in the courtroom. Then he said quietly, "No further questions." The boy stepped down from the witness stand and returned to the defense table. Foster's face was pale. She'd hoped putting him on the stand would humanize him. Instead, he'd confirmed every terrible thing the prosecution had argued, that he understood what happened, that he knew people were grieving, but that somewhere deep inside, where empathy and remorse should live, there was only emptiness, only concern for how events affected him personally, only regret that circumstances were inconvenient. The jury had seen enough. Some looked away as he passed. Others stared with expressions that mixed horror and sadness. One older man in the front row shook his head slowly, a gesture of disbelief that someone so young could be so utterly devoid of genuine feeling. The defense rested the following morning. There was little else Margaret Foster could do. Expert witnesses had testified about brain development and rehabilitation potential. Character witnesses had described a quiet child who'd never shown violence before, but none of it could overcome what the jury had seen and heard. The evidence was overwhelming. The defendant's own testimony had sealed his fate. Closing arguments began that afternoon, each side making their final appeal to 12 people who held an impossible responsibility in their hands. Foster spoke first, her voice passionate but strained. She reminded them of his age, reminded them that children were different from adults, that the law recognized this difference for important reasons. She asked them to consider what kind of society punishes children as harshly as adults, whether vengeance served any purpose, whether there was any hope for rehabilitation if they condemned a 13-year-old to decades behind bars. Robert Chen's closing was different, quieter, more measured. He didn't argue for vengeance, didn't ask the jury to punish out of anger. Instead, he talked about Sarah Mitchell, about a woman who'd worked herself to exhaustion trying to provide for her child, who'd sacrificed everything and asked for nothing in return except perhaps a little kindness, a little appreciation, a little love. He talked about the evidence, about planning and research and deliberate choices made over weeks, about a defendant who understood consequences and chose his path anyway, about justice not being about revenge but about accountability, about society's obligation to recognize that some actions, regardless of who commits them, demand serious consequences. He spoke for 18 minutes. When he finished, several jurors were crying. The defendant sat motionless, expression unchanged, as if the words were about someone else entirely. The jury deliberated for 2 days, 14 hours total, spread across intense sessions where they reviewed evidence, debated testimony, struggled with questions that had no easy answers. They sent notes to the judge asking for clarification on legal standards, asked to review the digital evidence again, asked to hear portions of Dr. Hartford's testimony read back. On the second day, they sent a final note. A verdict had been reached. The courtroom filled within 30 minutes, news spreading quickly through text messages and social media. Everyone wanted to be there for this moment, the moment when 12 strangers would declare what they believed justice required. The jury filed in, faces serious and worn. None of them looked at the defendant. That was usually a bad sign for the defense. Judge Moreland asked if they'd reached a unanimous verdict. The foreman, a retired teacher, stood and said yes, guilty on all charges. The word hung in the air like smoke. Guilty. A 13-year-old child convicted as an adult of intentionally causing the death of his own mother. The victim's family wept openly. The defendant showed no reaction, no surprise, no fear, no emotion at all. Just that same blank expression he'd worn throughout the entire trial. Judge Moreland thanked the jury for their service, acknowledged the difficulty of their task, and set a sentencing hearing for 3 weeks later. She explained that sentencing in cases involving juvenile defendants tried as adults was complex, requiring additional reports and considerations. She would review everything carefully before making her decision. The gavel struck. The trial phase was over, but the hardest part was still ahead, determining what punishment fit a crime committed by someone barely into adolescence. Those 3 weeks felt endless for everyone involved. The prosecution prepared sentencing recommendations, arguing that the severity of the crime and the defendant's clear understanding of his actions warranted the maximum penalty allowed under law. The defense prepared mitigation arguments, bringing in more experts to testify about rehabilitation potential, about the cruelty of essentially giving up on a child before his life had truly begun. Victim impact statements were prepared. Sarah Mitchell's family would finally have the opportunity to speak directly about their loss, their grief, their belief about what justice required. The community continued to debate, though the conversation had shifted, no longer arguing about guilt or innocence. Now the question was simpler and somehow even more difficult. What do you do with a child who commits an adult crime? Judge Moreland spent those weeks in her chambers, surrounded by case law and psychological reports and sentencing guidelines that seemed inadequate for a situation like this. She'd presided over the bench for 16 years, had sentenced hundreds of defendants, had seen terrible crimes and heartbreaking circumstances. But this case was different. She couldn't escape the fundamental tension at its core. He was 13, still legally a child, still protected by laws designed to recognize that young people deserve different treatment than adults. But he'd also planned and executed an act of profound violence against the person who'd loved him most, had shown no remorse, no genuine understanding of the human cost of his actions. The law gave her discretion, wide latitude to craft a sentence that balanced accountability with the recognition of his age. But what did balance look like in a case like this? She read studies on juvenile brain development, read cases where young offenders had been given long sentences and later showed genuine rehabilitation. Read cases where leniency had been granted and defendants had reoffended, causing more harm. She thought about Sarah Mitchell, about a life cut short, about potential that would never be realized. She thought about the defendant, about a child who might spend the majority of his life incarcerated, about whether that served any purpose beyond satisfying society's need to punish. She thought about deterrence, about what message this case would send to other young people who might be contemplating violence. She thought about her own conscience, about what she could live with, about whether mercy and justice could coexist in a case this severe. The night before sentencing, she sat alone in her chambers, long long after everyone else had gone home. The courthouse was silent except for the hum of fluorescent lights and the occasional footstep of security guards making rounds. She read through the case file one more time, looked at photos of Sarah Mitchell, looked at the defendant's school pictures, showing a child who should have been worrying about homework and friendships, not criminal charges and prison sentences. She thought about the purpose of the justice system: punishment, deterrence, rehabilitation, protection of society. How did you weigh those purposes when the defendant was barely a teenager? She didn't sleep much that night. By morning, she'd made her decision. Whether it was the right one, history would judge. But it was the one her conscience and her understanding of the law demanded. The sentencing hearing was set for 9 o'clock. The courtroom would be packed. The nation would be watching, and she would deliver a ruling that would define not just this case, but the ongoing conversation about how society treats its youngest offenders. The night before sentencing, nobody slept well. Sarah Mitchell's brother sat in his living room until 3 in the morning, rewriting the victim impact statement he'd practiced dozens of times. Every version felt inadequate. How do you summarize a person's worth in a few minutes of courtroom testimony? How do you explain the hole left behind when someone is taken violently, permanently, without warning? He crossed out sentences and rewrote them, added details about his sister's kindness, then removed them because they made him cry too hard to continue. Tried to focus on facts instead of feelings, then realized facts couldn't capture what had been lost. By dawn, he had 17 handwritten pages. He would have 5 minutes to speak. 5 minutes to represent 34 years of life, of memories, of love that would never be returned. It felt impossible. Margaret Foster sat in her office, surrounded by legal briefs and precedent cases, searching for any argument she hadn't already made, any angle that might convince Judge Moreland to show mercy in sentencing. She'd prepared appeals already, knowing that whatever sentence was handed down would likely face challenge. But she wanted to exhaust every option at this level first. She reviewed studies on rehabilitation success rates for juvenile offenders, found cases where young defendants had been given second chances and gone on to lead productive lives, highlighted passages that emphasized the difference between adolescent and adult brain function, built arguments around the fundamental question of whether society benefited more from punishment or from attempting to salvage a young life. Her eyes burned from staring at screens and documents. Her coffee had gone cold hours ago, but she kept working because that's what defense attorneys did, fought until there was nothing left to fight with. Across town, Robert Chen sat with the victim's family, going over what would happen in court the next morning. He explained the process step by step. The judge would hear from both sides. Victim impact statements would be read. The defense would make a final plea for leniency. Then Judge Moreland would announce her decision. He warned them that sentencing in juvenile cases was unpredictable, that even with a guilty verdict, the judge had wide discretion. The family listened quietly, holding hands, supporting each other through anticipation that felt unbearable. Sarah's mother asked the question they were all thinking. Would the sentence match the crime? Would justice be done for her daughter? Chen chose his words carefully, said he believed in the system, believed in Judge Moreland's integrity, but he couldn't promise any specific outcome. All they could do was speak their truth and trust that it would be heard. The community remained divided even now, on the eve of sentencing. Social media filled with predictions and demands. Some called for maximum punishment, arguing that anything less would send a message that youth excused violence. Others begged for mercy, insisting that condemning a child to decades in prison served no purpose beyond satisfying a desire for revenge. Religious leaders issued statements calling for both justice and compassion, though they disagreed on what that balance looked like. Mental health advocates used the case to push for better childhood intervention services, arguing that tragedies like this could be prevented with proper support systems. Victims' rights groups countered that prevention was important but couldn't undo harm already caused. The conversation continued in endless circles, everyone certain of their position, few willing to acknowledge the genuine difficulty of the questions at hand. Local news stations prepared special coverage for the next day. Reporters reviewed their notes, practiced their stand-ups, coordinated with camera operators and producers. This sentencing would be broadcast live. Every word from the judge would be analyzed immediately by legal experts in studios. Social media would explode with reactions in real time. The case had become national news, a flashpoint for larger debates about criminal justice, childhood development, and societal values. What happened tomorrow in that courtroom would echo far beyond the individuals directly involved. It would influence policy discussions, academic research, future cases involving young offenders. The weight of that broader significance pressed down on everyone who understood what was at stake. This wasn't just about one boy and one victim anymore. It was about how America understood accountability, mercy, and the purpose of punishment. The courthouse remained lit throughout the night. Security personnel checked the building multiple times, making sure everything was ready for the crowds expected the next morning. Metal detectors were tested, seating arrangements finalized, media positions assigned. Extra bailiffs were scheduled to handle crowd control. The building itself seemed to hold its breath, aware that within hours it would host a moment that people would reference for years to come. A case that would be taught in law schools, debated in ethics classes, cited in future legal arguments. The courthouse had witnessed many significant moments in its 70-year history, but few would carry the emotional and philosophical weight of what was about to unfold. Inside the juvenile detention facility, where the defendant had been held during trial, staff noted that he remained unchanged, no visible anxiety about the coming sentencing, no sleeplessness or loss of appetite that might indicate fear or regret. He ate his meals, read books, answered questions when spoken to, but showed no emotional response to the reality that his future would be determined in a matter of hours. Some staff found this eerie. Others had grown accustomed to his flat effect over the months he'd been in their facility. They'd tried to reach him, to find some spark of genuine feeling beneath the surface, but nothing had worked. He remained isolated, not by walls, but by his own emotional disconnection. Whether that would ever change, whether rehabilitation was even possible for someone so detached, remained an unanswered question. Dawn broke cold and gray. The sun rose reluctantly behind thick clouds that threatened rain. People began gathering outside the courthouse before 6 o'clock, hours before the hearing was scheduled to begin. Some held signs, some held photos of Sarah Mitchell, some came simply to witness. To be present for a moment, they sensed was historically significant. Television trucks claimed their positions. Reporters checked equipment and reviewed prepared remarks. Inside, bailiffs and court staff arrived early, moving through their preparations with extra care. Judge Moreland entered her chambers at 7:30, an hour before she typically arrived. She needed time to center herself, to review her notes one final time, to prepare mentally for what she was about to do. At 8:45, she put on her robes, looked at herself in the mirror, and walked toward the courtroom where hundreds of people waited to hear what she believed justice required. The longest night was over. The moment of truth had arrived. The courtroom filled to capacity by 8:55, every seat taken, standing room occupied. Overflow crowds watched on monitors in adjacent rooms. The atmosphere felt electric, charged with anticipation and dread in equal measure. Families sat on opposite sides of the gallery as if separated by an invisible wall. Sarah Mitchell's relatives on the left, holding tissues and photographs. Supporters of juvenile justice reform on the right, some wearing shirts with slogans about rehabilitation and second chances. In the middle, media representatives and legal observers waited with notebooks ready. Everyone understood this was history unfolding, a decision that would be cited and debated for decades. At precisely 9 o'clock, the bailiff called the room to order. Judge Moreland entered, her face composed but grave. She took her seat slowly, arranged the papers before her, and looked out over the packed courtroom with eyes that had clearly carried the weight of this decision through a sleepless night. She began by addressing the unusual nature of the case, acknowledged the strong feelings on all sides, reminded everyone that her role was to apply the law as written, informed by conscience, but not controlled by emotion. She said the court had reviewed extensive evidence, heard compelling arguments from both sides, and considered the interests of justice alongside the recognition that the defendant was a child when these events occurred. She spoke about the tension inherent in cases like this, the need to hold people accountable while recognizing that children were different from adults, that the law itself acknowledged this difference, but that some actions were so severe, so calculated, so devastating that age alone could not excuse them. Her words were measured, each sentence carefully constructed. The courtroom listened in absolute silence. Then she invited victim impact statements. Sarah Mitchell's brother approached the podium with shaking hands. He pulled out his prepared remarks, but found he couldn't read them. Instead, he spoke from the heart, talked about his sister's laughter, her determination, her love for the son who'd taken her life. He described the night he got the call, the moment he understood she was gone, the funeral where her son's chair sat empty because he was already in custody. He talked about his mother, who'd lost a daughter and now faced burying her while her grandson sat in juvenile detention, about nieces and nephews who would grow up without their aunt, about holidays that would forever be marked by her absence. His voice broke multiple times. When he finished, he looked directly at the defendant and said, "She loved you more than anything, and you erased her like she meant nothing." The defendant's expression didn't change. Margaret Foster made a final plea for leniency, spoke about her client's age, about brain science, about the purpose of juvenile justice being rehabilitation rather than retribution. She brought up cases where young offenders had been given opportunities for redemption and succeeded, asked the court to consider that a sentence of decades effectively ended her client's life before it had truly begun, that somewhere inside this troubled child might be the capacity for growth, for change, for eventually understanding the magnitude of what he'd done. She acknowledged the pain of the victim's family, acknowledged that no sentence could restore what was lost, but argued that adding another destroyed life to this tragedy served no purpose. Her words were passionate and professionally delivered, but they felt hollow against the weight of evidence that had been presented, against the defendant's own testimony, revealing the emptiness where remorse should have lived. Judge Moreland asked the defendant if he wished to speak. He stood, looked at her, and said in that same flat voice, "I know people are upset. I understand that. Nothing more. No apology. No acknowledgement of responsibility. No recognition of his mother as a person rather than a circumstance that had upset people." The judge nodded slowly, gestured for him to sit, and then picked up the document that contained her decision. She read from it directly, her voice steady but heavy with the burden of what she was about to impose. She acknowledged his age, acknowledged the complexity of the case, but then she outlined the evidence that could not be ignored. The planning, the research, the clear understanding of right and wrong, the absence of genuine remorse, the psychological evaluations that showed emotional detachment so profound it suggested future danger. She spoke about Sarah Mitchell, about a mother who deserved justice, about the finality of death, about how rehabilitation was important but could not supersede accountability for actions this severe. She cited case law, legal standards, the balancing test the law required her to apply. And then she announced her decision, the maximum sentence allowed under state law for a juvenile convicted as an adult. Life imprisonment with the possibility of parole, but the possibility would not come for 40 years, 4 decades before he could even petition for release, before a parole board could assess whether he'd developed the capacity for empathy and remorse that he currently lacked. The sentence meant he would be 53 years old before having any chance of freedom. Effectively, his childhood, adolescence, and much of his adult life would be spent behind bars. The courtroom erupted. Some people gasped, others wept. A few called out in anger or approval before being silenced by bailiffs. The victim's family embraced, crying tears that mixed grief with something that might have been relief. Margaret Foster sat with her head in her hands. The defendant remained motionless, face blank, as if the judge had been reading the weather forecast rather than determining the course of his entire existence. Judge Moreland raised her hand for silence, said she understood this decision would not satisfy everyone, that some would see it as too harsh, while others saw it as too lenient. But it was the decision she believed the law and her conscience required. She acknowledged the tragedy of it all. A life lost, another life confined, a family shattered, a community divided. No winners, only loss measured in different ways. She spoke her final words slowly, making sure every person in that courtroom understood. This court recognizes that you are 13 years old, but this court also recognizes that you planned, researched, and executed an act of profound violence against the person who loved you most. You understood it was wrong. You did it anyway. Justice demands that such actions carry consequences, not out of vengeance, but out of recognition that we are all accountable for our choices. Even young people, even children, perhaps especially when those children show clear capacity to understand the weight of what they're doing. She paused, looked directly at the defendant one last time, and added, "May you one day find the empathy that seems absent now. May you one day genuinely understand what you took from this world, and may that understanding lead to the remorse that should have been here today." The gavel struck with a sound that echoed through through the silent courtroom. Final, absolute, irrevocable. The defendant was led away by bailiffs, still showing no emotion, still disconnected from the reality of what had just happened. He would be transferred to a facility for juvenile offenders, held there until he turned 18, then moved to adult prison for the remainder of his sentence, 40 years minimum before parole consideration. The courtroom slowly emptied, people moving in stunned silence or heated conversation. Judge Moreland remained on the bench for a moment after everyone had gone, sitting alone in the empty room. She had delivered justice as she understood it. Whether it was the right decision, only time would tell, but it was done. The sentence had been pronounced, and now everyone involved would have to find a way to live with it. The verdict and sentencing dominated news coverage for days. Every major outlet ran analysis pieces. Legal experts appeared on television programs debating whether the sentence was appropriate. Some argued it was too harsh, that condemning a 13-year-old to 4 decades behind bars contradicted everything research showed about adolescent development and rehabilitation potential. Others argued it was justified given the evidence of planning and the complete absence of remorse. The conversation spread beyond legal circles into broader cultural debates. Parenting experts discussed warning signs families should watch for. Mental health professionals talked about childhood emotional disorders and when intervention was possible. Educators debated their role in identifying troubled students before situations escalated. The case became a mirror reflecting society's deepest questions about childhood, responsibility, and the purpose of punishment. Sarah Mitchell's family issued a brief statement through their attorney. They thanked the judge for recognizing their loss, said no sentence could bring back their daughter and sister, but that accountability mattered. They asked for privacy to grieve away from cameras and commentary. The statement was dignified and restrained, but those who knew them said the family remained fractured by the tragedy. Some felt the sentence was appropriate. Others struggled with the idea of a child spending most of his life incarcerated. The division that had split the community ran through the victim's own family. They agreed on one thing only, that Sarah had deserved better, deserved to see her son grow up, deserved to eventually rest from the exhaustion that had defined her final years, deserved a future that had been stolen with calculation and without mercy. The juvenile justice reform community mobilized around the case, using it to highlight what they saw as fundamental flaws in allowing children to be prosecuted as adults. Petitions circulated demanding changes to state law. Organizations held rallies and press conferences. They pointed to international standards, suggesting that life sentences for juveniles violated human rights principles. Cited studies showing that brain development continued into the mid-20s, that adolescents literally lacked the neurological capacity for adult-level judgment. They argued that the defendant could have been held accountable through the juvenile system, receiving intensive intervention and treatment until age 21, then transitioning to supervised release with continued support. That this approach would serve public safety better than warehousing a child in adult prison, where rehabilitation resources were minimal and exposure to hardened criminals was constant. Prosecutors and victims' rights advocates countered with their own arguments, pointed out that the defendant had shown sophisticated planning abilities, clear understanding of consequences, and deliberate efforts to avoid detection, that this wasn't a case of impulsivity or poor judgment, but of calculated violence. They argued that some actions were so severe that age couldn't excuse them, that justice required proportional consequences, that victims and their families deserved to see accountability that reflected the magnitude of harm caused. They emphasized that the sentence included possibility of parole, that it wasn't truly life without hope, that if the defendant demonstrated genuine rehabilitation over decades, he could eventually be released. The debate continued in editorials, academic journals, legislative hearings. The case had become larger than the individuals involved. It was now a symbol used by all sides to advance broader agendas. Legal scholars studied the case for precedent implications. Law review articles analyzed Judge Moreland's reasoning, comparing it to other cases involving juvenile defendants tried as adults. Some praised her careful balancing of competing interests, her acknowledgement of both the defendant's age and the severity of his actions. Others criticized the sentence as effectively defeating the purpose of recognizing childhood as a distinct legal legal category. The case was cited in appellate briefs across the country, used to support arguments both for and against harsh sentences for young offenders. It appeared in law school curricula as an example of the tension between juvenile rehabilitation philosophy and serious violent crime. Students debated what they would have done in Judge Moreland's position. Few found easy answers. Most concluded that some cases simply contain no good options, only choices between different types of imperfection. Margaret Foster filed an appeal within 30 days, as expected. The appellate brief argued that the sentence was constitutionally excessive for a 13-year-old defendant, that it violated evolving standards of decency, that it failed to adequately consider mitigating factors related to youth. The prosecution filed a response defending the sentence as within legal parameters and appropriate given the specific facts. The appeal would take years to work through the system. During that time, the defendant would remain incarcerated, moved from juvenile detention to adult prison as he aged. Foster vowed to continue fighting, to exhaust every legal avenue. She believed deeply that the sentence was unjust, regardless of what her client had done. That was her job. To fight for him even when no one else would, even when he showed no appreciation for the effort, even when his own actions made her job nearly impossible. The facility where the defendant was held reported that his behavior remained consistent with what professionals had observed throughout the trial. Compliant, but emotionally distant. He followed rules, completed assigned tasks, attended mandated counseling sessions. But therapists noted the same emptiness that psychologists had documented. He could discuss his actions intellectually, could explain why society viewed them as wrong, could articulate understanding of the victim's family's grief. But he showed no genuine emotional connection to any of it, no breakthrough moments where authentic remorse appeared. Some clinicians held out hope that maturity might eventually bring change, that somewhere in the decades ahead, the capacity for empathy might develop. Others were less optimistic, believing that whatever fundamental emotional capacity was missing might never emerge regardless of time or intervention. Only years would reveal which assessment was correct. At Sarah Mitchell's grave, flowers appeared regularly. Anonymous visitors left notes expressing condolences and anger. Her brother visited every Sunday, sitting on the grass beside the headstone, talking to her about everything she was missing, about family events she should have attended, about the justice system's attempt to address what happened, about his own struggle to find meaning in a loss so profound and unnecessary. The headstone was simple, her name, her dates, and a single line underneath. Devoted mother, loving sister, forever missed. No mention of how she died. No reference to the trial, or the conviction, or the sentence that had consumed so much attention. Just recognition of who she was to the people who loved her. A person, not a victim, not a case number, not a symbol in broader debates. Just Sarah. A woman who deserved to still be here, whose absence left a hole nothing could fill. In classrooms and community centers, the case sparked difficult conversations. Teachers used it to discuss choices and consequences with their students, trying to find age-appropriate ways to convey that actions mattered regardless of age. Parents talked with their children about empathy, about recognizing when someone might be struggling, about the importance of seeking help before situations became critical. Mental health professionals offered workshops on warning signs of emotional detachment in young people. The tragedy couldn't be undone, but perhaps it could prevent future tragedies if people learned to recognize red flags earlier, to intervene before thoughts became plans and plans became actions. That was the hope, anyway. That meaning could be salvaged from meaningless loss. That Sarah Mitchell's death might somehow lead to lives saved. It was small comfort, but it was something. And in the aftermath of such profound darkness, even small lights mattered. Years would pass. The headlines would fade. New cases would capture public attention. The intense scrutiny that had surrounded this trial would eventually dim, replaced by other controversies, other tragedies, other questions about justice and mercy that society would struggle to answer. But for those directly touched by this case, time would not bring the kind of healing that erases scars. Instead, it would simply teach them how to carry weight that never truly lightened. Sarah Mitchell's family would continue living with an absence that no amount of time could fill. The defendant would continue serving a sentence measured in decades, his youth slipping away behind walls and razor wire. Judge Moreland would continue carrying the burden of her decision, wondering on difficult nights whether she'd struck the right balance or whether true balance balance was even possible in cases like this. The question had no simple answer. Perhaps it had no answer at all. The case became part of legal history, cited in courtrooms across the country whenever prosecutors and defense attorneys argued about juvenile offenders and adult consequences. Law students studied it, debating what they would have done differently, what justice should look like when childhood and violence collide. Psychologists referenced it when discussing emotional development and the rare cases where empathy seemed fundamentally absent. Criminologists analyzed it for patterns, for warning signs, for lessons that might prevent future tragedies. The defendant became a case study, a data point, an example used to support various theories about nature versus nurture, about whether some people were born without the capacity for genuine human connection, or whether circumstances created that emptiness. The questions multiplied. The answers remained elusive. All that was certain was the loss. And loss, once created, could never be completely undone. Inside the prison system, the years changed his appearance, but not his fundamental nature. He grew taller, his voice deepened, his features matured from child to teenager to adult. But the flatness remained. The emotional distance that had disturbed everyone who'd encountered him didn't evolve into something healthier. Therapists worked with him, trying different approaches, different techniques designed to unlock empathy or remorse or some spark of genuine human feeling. Some days they thought they saw progress, a moment where he seemed to grasp the weight of what he'd done. But those moments never lasted, never developed into sustained change. He learned to say the right things, to perform remorse in ways that might eventually help at parole hearings decades in the future. But performance wasn't the same as authentic transformation. Those who worked with him longest came to understand that whatever fundamental capacity was missing might never develop, regardless of intervention or time. Outside, Sarah Mitchell's legacy lived in small ways. A scholarship fund established in her name helped nursing students complete their education. Co-workers at the hospital kept her photo in the break room, a reminder of dedication and kindness. Her brother ensured his own children knew their aunt through stories and memories, refusing to let her be reduced to the circumstances of her death. She had been more than a victim. She had been a person with dreams and fears and hopes for a future she never got to see. Keeping that truth alive mattered, especially when so much public discourse focused on legal questions and policy debates that sometimes seemed to forget a real human being had been lost, a woman who'd loved fiercely despite exhaustion, who'd worked tirelessly to provide for a child who'd never appreciated her sacrifices, who'd died believing tomorrow might finally bring the connection she'd been seeking. That belief had been wrong, and she'd paid for that wrongness with everything. The criminal justice system moved forward, as it always did. Other cases filled courtrooms. Other families faced impossible losses. Other defendants sat in those same chairs, wondering what fate awaited them. The machinery of law and consequence continued its work, imperfect but necessary, trying to balance punishment with mercy, accountability with hope, society's need for safety with recognition that people could change. The balance was never perfect. In cases like this one, perfect balance might not even exist. How do you weigh a 13-year-old's future against a mother's stolen life? How do you measure rehabilitation potential against evidence of profound emotional deficit? How do you serve justice when every option feels inadequate? Judge Moreland's decision had been one answer. Whether it was the right answer would be debated for generations, but it was an answer. And in a system built on human judgment applied to impossibly complex situations, that was sometimes the best anyone could offer. On quiet nights, in the stillness that comes after chaos has subsided and attention has moved elsewhere, the fundamental questions remained. What creates a child capable of planning and executing such violence? What failures in family, in community, in mental health systems allow such situations to develop? Could this tragedy have been prevented with earlier intervention? Or was the defendant fundamentally different in ways that no amount of support could have addressed? The experts disagreed. The research provided no definitive answers. All that remained were two lives irrevocably altered. One ended far too soon. One confined for decades in consequence. And between them, a chasm of loss that justice could acknowledge but never truly bridge. Judge Moreland's words from that sentencing hearing echoed in the minds of everyone who'd been present. We are all accountable for our choices. Simple words that carried profound weight. The defendant had made a choice, researched it, planned it, executed it with full awareness of what he was doing. The evidence had proven that beyond any reasonable doubt. And choices, once made, created consequences that rippled outward in ways that couldn't be contained or controlled. Sarah Mitchell had made choices too. To keep working despite exhaustion, to keep loving despite distance, to believe that tomorrow might bring understanding. Those choices had ended in tragedy she didn't deserve. The unfairness of it was staggering, but fairness was never guaranteed. Only accountability, only the recognition that actions mattered, that lives had value, that justice, however imperfect, was still worth pursuing. The case would never truly close for those it touched most deeply. Time would pass. Seasons would change. Life would continue in its relentless forward motion, but the weight would remain. A mother gone, a child condemned, a family shattered, a community forced to confront uncomfortable truths about what even young people were capable of when empathy failed and violence took its place. The courtroom had delivered its verdict. Society had imposed its punishment. But the deeper questions lingered in spaces no legal system could reach. Questions about human nature and moral development. About when childhood ended and accountability began. About whether some people were born missing essential pieces of humanity, or whether the world broke them in ways too subtle to see until it was too late. The answers, if they existed, remained elusive, hidden in the complex intersection of biology and environment, choice and circumstance, nature and nurture. All that was certain was the ending, and the beginning of everything that came after. Some crimes steal a life, others steal the future. This one did both.